Cohens here again, Constitutional Kook headquarters, more with news and current events. And this involves the recent oral argument before the 9-0 Parts, aka the U.S. Supreme Court, about overturning, quote unquote, the Roe v. Wade decision. About 50 years old, been around, and supposedly gives people the right to an abortion. Ain't. Never was designed that way. Shouldn't have been decided on that issue in any event. And it was contemporaneously known on the court as Harry's abortion because it was written by hip pocket Harry Blackman, who was a really good person, by the way. I'm making a little joke about it here, but he wrote the thing and didn't cite any particular provision of the Constitution that was involved here. So what it comes down to is the due process clause of the non-existent 14th War Amendment. Waste of time, waste of money. I mean, he got to the right conclusion, but for the wrong reason. And as T.S. Eliot once said about that sort of thing, the last temptation is the final treason, to do the right thing for the wrong reason. So what's going on here doesn't matter a whit. If you get with me and learn the unopposed issues that I advocate pursuant to all 6 articles of the Constitution for the United States, 1787 to 1791, you're going to do a whole hell of a lot better. And you can do that. Send me an email, uwinningcourt@gmail.com. I'll get you out info on what I do and how I do it. You're going to love it. It's a whole new world out there. And at least those 9 parts know it. So it doesn't matter what happens here. Because what you do is that you go in there, and among other issues, we present that we have the unlimited power to contract pursuant to Article 1, Section 10 of the U.S. Constitution and or the 9th and 10th Amendments thereto. And in that capacity, we can pretty well do what we damn well please. But it gets even better because these laws enacted by state legislatures, listen up close here in Jackson, Mississippi, and Austin, Texas in particular. If there are no states left in this union which were admitted into this union as states pursuant to Article 4, Section 3 of the U.S. Constitution, and that's the crown jewel of all the unopposed constitutional issues I advocate, then there are no laws on the books, and you don't have to get any further than that. Doesn't matter, whether it's abortion, whether it's with your mortgage banker, anything, criminal law, anything like that. They're not on the books. They were never enacted because they all come from a legislature in which at least the members of the sovereign body politic of the nation and republic are not and were not represented. This brings up the 4 magic words that I keep repeating: consent of the governed. It's not there, and they can't prove it. And that's how we beat the bastards. Send me an email, uwinningcourt@gmail.com. I'll get you information right back at you, what I have, how it works, modestly priced materials you can use in any setting. Abortions, criminal law, mortgage, banksters, student loans, you name it. It's astounding what the framers of our Constitution did and set up the best government that's ever been created in the entire course of history. No, it wasn't perfect. No one's saying that. But it was the best one we had, and we need to get back to it. And we can then make changes from there if we want to, consistent with the Constitution, not in contravention of all 6 articles of it, like I can prove a cappella. It's the case with the non-existent 14th War Amendment. All 6 articles. And this has never been before the 9-0 farts in 160 odd years. Or are you listening, John Roberts, Sam Alito, Clarence Thomas? And by the way, with events having occurred in the last term of the court and ongoing in this term, we may actually be in an unprecedented window of opportunity here where we can present questions like this, which we have every right to do. And this is the U.S. Supreme Court saying it, not me. Case is called Cohens v. Virginia, 6 Wheaton 264, 1820, I believe. And it's John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? And what did he say there? This is almost an exact quote. The Constitution gave to each person a right to present his case to the court of the nation, no matter how small the claim nor how little interest the community in its outcome. The framers of our Constitution thought it important in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. Now, today, you can't even get documents filed in a fucking trial court. What has happened here in the last 100 odd years? Well, you learn all that and more. Send me an email, youwinningcourt@gmail.com, and I'll tell you why we can't get documents filed. And by the way, when I started out 5 decades ago, back in the 1980s, we could actually do it. Um, but even in that period of time since I've been doing this, I've never had any of them answered or even acknowledged because the local dumbass can't do it. Because if they attempt to do that on the record, it convicts every official actor in that courtroom, quote unquote, of treason to the Constitution. And there's that pesky 90 Parks again in the same case, Cohens v. Virginia. You're going to love to learn about this case. Best decision they ever made. Send me an email, youwinningcourt@gmail.com. And they said, in effect, that for a court to exercise jurisdiction it doesn't have, or to refuse to exercise jurisdiction it has, the one or the other is treason to the Constitution. And I have a quote from a later case, one of the few that I don't have from the U.S. Supreme Court, where a federal judge threw out an indictment for murder. And I won't go into the long story about that here, but it was in Montana, and the Montana Supreme Court erred on what the state law was. So the U.S. attorney filed an indictment, for murder in the federal district court. The trial judge is throwing it out, and this is an exact quote. It's unfortunate that a murderer should go unwhipped of justice, but more unfortunate that a court without jurisdiction should exercise it. Case is Tully v. United States, 140 Federal Reporter, 899, page 905. What the hell is going on here today? Where you got people like Julius Jones, for example, that was recently granted quote unquote clemency in a case where he probably didn't do anything and shouldn't have been on death row. And the Oklahoma governor should have set him free there and then. Are you listening out there in Oklahoma City? My goodness. But this is how bad this system is. They don't care. All they want to do is get a conviction. They don't care how they get it or anything else. By the way, very recent news is Scott Peterson had just had his sentence reduced, quote unquote, to life imprisonment without parole. And here's another situation that, and this was a local one, the trial, quote unquote, occurred real close to where I was at the time. And he got screwed over like everyone else in the system does, and had his attorney exercise his due diligence. Are you listening out there, Mark Garagos? He should have challenged jurisdiction of the court. There would have been no trial for the very reason I said, coming from Tully v. United States, no matter what happened or did not happen. And that's the kind of changes we have to make to get back to the government we should have, Republican form of government of defined and limited powers, not the democracy we have now. 3 wolves, 2 sheep, voting on what's for dinner. Very same democracy, by the way, they have in Pyongyang, North Korea. And you can judge for yourself how worthwhile living life is over there. How every dude giving them a break there to give them a vaccine and put them all out of commission so that they wipe out the entire nation of North Korea. That would be doing them a favor, given what they go through on a daily basis. And it's getting worse and worse here. I mean, the differences between these two nations is really getting a lot closer than you might think. And that's the way that the one worlders want it out there, Elon Musk, Bill Gates. It's exactly what they think. They have no respect for human life, don't care, don't think we have any rights they're bound to respect. And that's why they can tell you what to do in a case like Roe v. Wade, which is not the issue at all. And by the way, what happens is that makes Roe easily distinguishable when your case gets there. If we're saying, Article 1, Section 10, and or the Ninth Amendment, particularly the Ninth Amendment, which, wouldn't you know, the Constitution was ratified in 1791. It took the U.S. Supreme Court, are you ready for this? About 164 years to make one ruling on the Ninth Amendment. Cases Griswold v. Connecticut in 1965, and I don't think there's been one since. Why is that, you ask? Aren't there people out there, especially in earlier generations like me, that did know, especially in the late 19th and maybe early 20th century, knew a lot of what I have come to know because I've done my due diligence, and now I have 230 years of Constitution, laws, and history at my command a cappella in a courtroom before a judge, or better yet, before a common law jury who has the power to rule on the facts and the law. That's the ultimate check and balance on these bastards, and this is what we have to start doing here. Whether it's criminal, whether it's Roe v. Wade, mortgage bankster, you name it. We get it to a jury like that, and you're going to have, by the way, you get my materials, the full order comes to almost 600 jury instructions. I would love to have been a fly on the wall in Columbia, South Carolina, when those jury instructions hit them. My friend out here sent them, and they had to look at that and say, what the hell is this? Because they knew, and I knew from day one, by the way. I was laughed at them in that case when I got arrested out here in a local library. That's hard to do. And I couldn't figure it out, and I was laughing at them from day one. And I didn't have a clue for at least the first few weeks what was even going on. Now I found out, and I got hauled all the way across country on 4 unmarked federal military aircraft to South Carolina, a jurisdiction in which I had never set foot. Shut the bastards up in 30 seconds of my first court appearance. It's $1 million video, which I would love to have, but they claim not to have made it in a court of record. But it was astounding. I'm the one standing there shackled, hand and foot, and in a red jail suit. They're the ones in trouble with the law, and everybody knew it. That's the power we have, and that's the way the Constitution was set up, to recognize that we have that power. You have it as well as I do, but you have to learn your rights, know them, and be able to take care of business in court. And it's really not that hard. You don't have to be near as good as I am. The ignorance is colossal on the other side. They just don't teach this stuff in law schools. They don't think they have to care because they don't think we have any rights or any remedies to make them pay for what they've done. I'm here to help you prove them wrong. We're going to set an unopposed record in the trial court. Whether it's an abortion case, whether it's a criminal case, mortgage banksters, you name it. And they're going to find out, since they're not acting in any official capacity, they don't have immunity. We're not bringing a BS civil rights claim here. 42 U.S.C. 1983, non-existent 14th War Amendment. And that's the strength we have, people. They can't have these issues come out in public, and that's why we probably never even have to file court papers. Because if that happens and we get one decision on the merits with an unopposed record in the trial court and a seemingly solid conservative majority on the U.S. Supreme Court today, not conservative in the way it was, let's say, during the New Deal era of the first term of Franklin D. Roosevelt, otherwise known as fascist dictator Roosevelt. It was comparatively conservative even then. But if we have that on the court now, and if they're ready to go the direction they appear to be, I discussed in the recent video a case called BST versus OSHA, where the Fifth Circuit summarily threw out the mandatory OSHA COVID vaccination in no uncertain terms, and they did it sounding exactly like me. If they're really ready to go and start questioning the extent of the Commerce Clause powers of Congress, we have a real chance here, people, a window unprecedented to get very close to what we used to have 150 years ago. The government of defined and limited powers, especially in my former hometown of Washington, D.C. There's a real chance to do it. And for those of you that have families and children and your posterity, you have, I think, a sworn duty to take it on and do it yourself, especially members of the body politic like I am, 3 white male and 21. And that's what it was, and that's what it is. I don't make any apologies about that. You can take that critical race BS and shove it up your sphincter. It is what it is. It wasn't perfect, but if we get back to it, that starting place can allow us to make changes in conformance with the Constitution, not in contravention of it. And now you go on and you have your rights, and you won't even have to deal with all this crap with the anti-abortion laws and all this, because none of it matters. For what it may be worth, by the way, I think I'm not untroubled by that, and I think it's far better you take care of business and see to it on both sides that no one becomes pregnant, especially if you don't want children. If you do, and there are issues with that, you may ultimately have to deal with that in an ecclesiastical court of conscience after you get to where it is you're headed, following your death here on earth. And that'll be an interesting explanation. I offer no opinion or advice on that one. But for our courts to get involved like this, no, should never have been the case. So it's astounding once you know the difference. And it took me a while. I was a slow learner. I did not get it overnight. You won't either. You're not going to have to spend the 10,000 hours I spent in those musty old stacks of law books. That's my job to help you get there, and with my documents to make it easy to do. And I want feedback, by the way, those of you that order my documents. Send me an email, youwinnincourt@gmail.com. I'm always looking for helpful comments and updates on how I can make it easier so you can learn it a lot quicker. Because once it hits you like it did me, and it took a while for that to happen. And I said, my God, what the hell is going on here? Instinctively, when I was growing up, I had some hints about this. And I grew up, by the way, I spent my summer times in Virginia and West Bygosh, Virginia, virtually in the shadow of Jeffersonian republicanism in an era when most people actually lived that way where I was living. And so I had some instinctive things that had I learned things in high school, my life would have been different over 50 years ago. By the way, I say West Bygosh, Virginia. I didn't know at the time what that meant, but I heard people say it there, including my grandfather. And that's one subject they never discussed, my mom told me at the table, was the war between the states, because as so often was the case, the families were on different sides. But I found out later, West Bygosh, Virginia, good old Dad Stevens, the head of the House during the 39th Congress and Reconstruction, Inc., conceded that West Virginia was admitted pursuant to the war powers of Congress, not Article 4, Section 3, not a state admitted into this union. There are no such states after Minnesota in 1859, and the ratification of the non-existent 14th War Amendment. You're going to learn, what that created was a subordinate body politic. All persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. Once you understand what that simple English means, it's astounding. It has nothing to do with us, nothing to do with state citizenship. And boy, do we have some authorities you're going to be putting in your paperwork and waking them up in a hurry, because that's the only jurisdiction they have. If you're not a 14th Amendment citizen, you have no official actors in there. They don't have any immunity. And we can set an unopposed record and come back and burn their ass. And that's what I want to help you to do. And yeah, there's a lot of money in it, but the reason we're going to beat them is you and I are going to go in there if we ever see a jury. And trust me, I'm never going to see one. Because what we want to do is make changes in the way the just us system does business. What do they have on the other side? A collection of goddamn state bar association attorneys and $2,000 designer suits. That's not going to work. They can't risk it. The magnitude of the issues. And that's the beauty of it. We have the power. You just have to understand that and to what extent we have that power. Well, if we do that and we get a lot of us out there, and it won't take a lot in any given jurisdiction, by the way, but if we know that and start acting on it and teaching our children and our posterity, that's what beats these bastards. That's what's exciting. That's why for me in my 74th year, life is still ahead of me. That's how good this is. They never want you to feel that at all, ever. Because once you do, you'll never turn back. And you'll keep on going and do the right thing for yourselves, your family, and your posterity. So that said, send me an email, youwinnincourt@gmail.com. I'll get the information out on what I have and what I do. In the meanwhile, remember, we all have to work together here and cut the divide and conquer crap out they've been doing for at least 160 odd years here, and go in there with the same status, the same issues, and the same arguments. And that's how we get these bastards off our backs. Remember to subscribe, like the videos, get the word out, tell your friends. Thank you.